What kind of questions does a judge have to ask a defendant before the defendant can be allowed to represent himself in a criminal case? To find out, you have to read People v. Baines. It's only 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of People v. Baines. This can be found at 2022 New York Slip Opinion 05919, published by the Court of Appeals on October 20th, 2022. This is a criminal case, and the issue here is about the sufficiency of a court's inquiry of a defendant who wants to proceed pro se, meaning represent him or herself. So, to understand this case, you have to understand a few of the principles underlying this issue. Basically, a criminal defendant, a defendant who's faced with going to jail, has a right to counsel, to be represented by counsel, or to represent themselves if they choose. But because they have this right to counsel, if they decide to go pro se, meaning represent themselves, the court has to make a searching inquiry to ascertain, to verify that the defendant has actually waived properly this right to counsel. And to make that searching inquiry, they have to make sure that it's knowing, voluntary, and intelligent. Those are the 3 key aspects. A knowing, voluntary, intelligent waiver of the right. Now, normally that inquiry involves, there's no specific script the judge has to use. Generally, they go into 3 different areas, which is pedigree. Pedigree is basically the kind of questions you might answer in a survey: your age, your level of education, your occupation, your previous experience with the criminal justice system. The second area is the danger of proceeding pro se, and the third area is the importance of a lawyer in an adversarial proceeding. So, what are the facts in this case? And then we'll talk about whether the judge did the appropriate thing here. The facts are the defendant is indicted. He's charged and indicted with promoting prostitution in the 3rd degree. He has a lawyer, but he tells the judge, I want to proceed pro se. I want to be my own lawyer. Basically, the judge assigns him an 18B counsel and ultimately recognizes that the defendant wants to be his own lawyer and assigns him a legal advisor. And a legal advisor is different than a lawyer. A lawyer speaks on the defendant's behalf. A legal advisor is just someone who the defendant can ask questions to help guide him, but really the defendant still speaks for himself. The defendant, in this case, was his own lawyer, proceeded pro se during the pretrial motions, pretrial suppression hearings, and ultimately picked and retained his own lawyer for trial. He was convicted, found guilty, appealed, and said, amongst his arguments, that the judge didn't properly, deprived him of his counsel because he didn't properly waive counsel. The appellate division affirmed what the trial judge had done, and it goes to the Court of Appeals. And what happened is the judge said to him, when the defendant said to the defendant, when he said, I want to go pro se, the judge made some inquiry and said to the defendant, this is not a good idea. This will put you in a very bad position. And also explained to the defendant that a lawyer would have knowledge of criminal procedure that the defendant doesn't have. And on those issues, the Court of Appeals says that was insufficient. The judge did not make a sufficient searching inquiry such that the court can be confident that the defendant knowingly, intelligently, and voluntarily waived his right to counsel. The court's generalized warnings were not appropriate, and the court should have addressed further the issues in this case. Specifically, the Court of Appeals notes that the court's discussion with the defendant should have addressed the goals of adequately warning the defendant about the risks inherent in a proceeding when he goes pro se, and also apprising the defendant of the singular importance, this is the language they use, of the singular importance of a lawyer in an adversarial proceeding. And in this case, telling the defendant it's not a good idea, that a lawyer has more information about criminal procedure, is not the same thing and is not sufficient. So they reverse it, goes back to the trial court. That's the case of People v. Baines. Too long, didn't read, 5 minutes or less. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.